In the murder trial of Lindsay Clancy in Massachusetts, the defense cross-examination of the prosecution's final witness has started. But now, before morning recess, Dr. Gregory Sapoff testified that he believes Clancy knew right from wrong. He also said he would have diagnosed her with bipolar II disorder if she was his patient. He's one of two forensic psychiatrists called by the prosecution, and each cast doubt on the defense theory that she was not in control of her actions that day when her children were killed. And one said there were inconsistencies in her recollection. Now let's bring in CBS News legal contributor Jessica Levinson. Jessica, thanks again for your time today. So what stood out to you on the prosecution's final witness?
So what stood out to me is the prosecution is obviously going to the heart of the defense's strategy here, arguing through forensic experts and through psychological experts, that Lindsay Clancy was not able to comport her behavior within the boundaries of the law, that she did not understand right from wrong. What we now see is the defense going after the prosecution's rebuttal witnesses. What we now see is this really strong battle of the experts on the specific point of whether or not Lindsay Clancy can be found culpable. We should remember that much of this case is settled. They're not fighting about who killed these children. They're not fighting about how it occurred. They're fighting about what was in Lindsay Clancy's mind at the time that these killings took place.
Yeah. And what's ultimately the goal for prosecutors during this rebuttal witness phase of the trial?
So the goal for prosecutors is to undercut everything that the jury heard when it comes to the defense witnesses. The goal for the prosecutors is to say, we know you have just heard from defense witnesses that Lindsay Clancy experienced command hallucinations, that she was not able to understand right from wrong, that she was essentially a puppet. But all of that is not true. The prosecution is going to say, we have our own witnesses to indicate, of course, she was suffering from mental illness. That is not on the table. Of course, that mental illness was profound. Nobody is questioning that. What the prosecution is saying is that it's just not credible to believe that her mental illness rose to the level here necessary for a jury to find that she cannot be punished for these killings. And again, I think it's all going to come down to who the jury finds most credible, what the jury finds to be most believable, because you have different experts essentially saying the opposite thing, which often will happen in a case like this. We have a true battle of the experts on this narrow point.
Yeah, and Jessica, I want to preface this by saying I know we obviously cannot read the mind of the jury, but once this case gets to them, do you think this is the kind of case where they might come with a decision really quickly, or is this going to take a while for them to decide? Because it really has been, which of these experts do we ultimately believe?
Well, that's right. And I'm going to answer by not answering, which is, this is one of the most difficult to predict aspects of any criminal trial, where if you're in the room and you're watching the jurors and you're watching their expression and you're looking to see, what's their body language, what are their nonverbal cues, then you can more often have a sense. But I will say, sometimes everybody gets it wrong. The jury has been able to talk about everything except the reason they're there. They've been able to talk about everything other than the case at hand. When they go back to that jury room, they're going to, my guess is, either be fairly unified or it'll be particularly splintered. If the case comes back quickly, conventional wisdom is that's good for the prosecution. If it takes longer, generally speaking, better for the defense. But this is not a conventional case. And the burden of proof for the prosecution in Massachusetts is different than is typical. Typically, this is an affirmative defense. So that's a long way of saying we'll have a better sense once we know how long the jury is back there deliberating.
That's a good answer there, Jessica Levinson. As always, thank you so much for your insight.